Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
When a contractor files a bid protest at GAO, the award usually pauses while the protest is reviewed. But recent court decisions are clarifying when agencies can override that stay and how closely judges will examine those decisions afterward. Here to help us understand the complexity of this contingency is Zach Prince, partner at Haynes Boone. Zach, thanks so much for joining me this morning.
Thanks for having me, Terry.
When contractors lose a bid and they go to GAO with a protest, that filing usually freezes the contract while the protest plays out. But sometimes agencies can override that pause. Walk us through the basic mechanics there. What triggers an automatic stay under the Competition and Contracting Act? And what does an agency have to do, at least on paper, to override that?
Sure. So the Competition and Contracting Act, or CICA, comes with an automatic stay of performance or stay of award, depending on whether it's pre or post-award challenge, for filing a GAO within a certain specified time period. So assuming you do that within the right amount of time, which can be its own fight, the agency is prevented from acting. But there's recognition, Congress, when they drafted and passed this act, understood that it doesn't always work, because sometimes there are urgent and compelling circumstances that necessitate the government moving forward anyway. So in that case, the agency head has to execute determination of findings, or DNF, documenting that there is this urgent and compelling circumstance significantly affecting interests of the U.S. that will not permit waiting on GAO decision, and then the government gets to proceed with performance or with award, depending on circumstances.
And so why does that override decision matter so much then, both for the government and for the contractor?
Well, from the government side, they get the work done that they need to. And often there are national security interests that are overriding, or other national concerns, and the government gets to proceed. From the contractor's perspective, this makes the bid protest process almost hollow. They might win, and GAO might tell the agency that they were wrong to have awarded to a competitor, but performance might be well underway, and there's not all that much that can be done at that point. I mean, maybe the agency will be told that they should terminate and award to the protester, but you've now lost out on maybe 90-something days of performance, or maybe the work is already done and it's too late.
So there is two recent cases that help clarify this process. Walk us through the active deployment systems case and the life science logistics case. They came out kind of at the same time.
Yeah, they did. So what happens with a CICA override, if you get notice as a protester that the agency is overriding the stay, you have to go to the Court of Federal Claims. And that's where you'll challenge the override decision as arbitrary and capricious and ask the court to stop the agency from moving forward. The way you do it is somewhat of a jurisdictional complication. Typically, folks will go and they'll ask for a temporary restraining order or preliminary injunction. In the life science logistics case, which went up to the Federal Circuit, they asked instead for what's called a declaratory judgment. And this is not a distinction without meaning. It's not just legalese, because when you ask for a preliminary injunction, you have to demonstrate a 4-factor test, not just that you're likely to win on the merits, but also weighing of interests. And it can get complicated. If you just ask for a declaratory judgment, all you have to do is demonstrate that you win on the merits. That is, the agency's decision was arbitrary and capricious. So the life sciences case, I'll start off with that because it's precedential and it's the Federal Circuit. This goes back a little bit. This concerns a award to manage the strategic national stockpile for the capital region. But what that is a nationwide network for storage and deployment of medicines, vaccines, and medical supplies. It's managed by part of HHS, but the contracts for the administration are handled by GSA. There are only a couple contractors that do this kind of work. And the protester in this case, Life Science Logistics, is one of maybe 3 or 4 that are out there. The complicated background of this case, it was challenged, and the procurement decision to award to a competitor was challenged, I think, in 2022. It went back and forth with the agency. Ultimately, the agency issued a SECA override. That is, they said, you know what, we need this, it's important, we're going to go ahead. The life science logistics went to the court. They asked for a declaratory judgment saying the agency was wrong to make this decision. The court agreed, and ultimately it went back to GAO. Life science logistics won on the merits, but the agency still appealed the decision to vacate the override to the Federal Circuit. And the reason they did it is because they said the court applied the wrong test. They should have asked for this four-factor analysis that you would apply to a preliminary injunction, not just asking, was it arbitrary and capricious? That is, you have to ask more. You have to ask, what is the balancing of the interest here? And is there an overriding interest of the United States that might override the interests of the protester? Kind of a wonky way to go down this, but ultimately now, 4 years after the first challenge was made in this case, the Federal Circuit agreed with the court and agreed with the protester that the appropriate test is not this four-factor balancing test. It is a simple question of, was the agency acting arbitrary and capriciously? That is, without any real justification for its decision to override. And if so, then the court will issue a declaratory judgment. They will say, agency, you cannot override. And so the decision will force the agency basically to live with the SECA stay while the GAO decision goes on for maximum 100 days. So we're not talking a long period of time.
Speaking with Zach Prince, he's a partner at Haynes Boone. Zach, catch us up then on the ADS case. How is that different?
So the ADS case was a challenge filed as a preliminary injunction request. So the traditional approach where ADS was disputing at GAO the decision by the Federal Law Enforcement Training Centers, or FLETC, to award to ADS's competitor for the construction of temporary housing facilities in New Mexico. This is to accommodate CBP agent trainees. So ADS filed its protest March 16th of this year. 2 days later, it was told that the agency was overriding the decision. They justified it on the basis of urgent and compelling need to hire and train CBP agents. They explained that there was no alternative housing available to them. They've got 500 additional trainees a day that they have to house. There were no offsite alternatives. It would have a delay. A delay would have an impact on national security and trainee safety. So they made that override decision. 14 days later, ADS filed suit at the Court of Federal Claims and asked the court to issue a temporary injunction prohibiting the agency from overriding the mandatory SECA stay.
So these two sound like very different contracts for very different services, and yet this override is at the center of them. When you put the two together, what sort of lessons do you take away, and what lessons should contractors be paying attention to here?
So first, just as a procedural matter, if the agency files or tells you that they're going to be overriding a SECA stay and you want to challenge it, make that decision quickly and file it at the Court of Federal Claims as a request for a declaratory judgment. That is, don't go through the process that used to be standard of asking for a preliminary injunction or a temporary restraining order. Instead, the Federal Circuit is very clear. You can just ask for a declaratory judgment. It will make your job easier.
And when you think through this, how should a contractor think about challenging an override decision? What sort of cases do they need to make?
So they need to be able to show that the agency was relying on some impermissible factors when they were making their determination. They failed to consider some important aspect of the overall posture. Their explanations are incoherent or illogical, or their conclusions illogical. Now, there are reasons that as a contractor, you don't want to challenge agency's decision. One is you're going to be annoying your customer. But two is there really might be very justifiable national security interests at stake here. And you have to know the situation and know whether that is likely to prevail, that is the agency's invocation of national security. And really, as a matter of policy, if their invocation of national security is appropriate. You might agree with them and you'd like them to have given it to you and let the SECA stay ride. But I've been involved in situations where it's obvious that there is, say, an urgent health issue and the agency can't wait. So you might want to challenge the SECA stay, but sometimes you just won't anyway.
Been speaking with Zach Prince. He's a partner at Haynes Boone. Zach, I really appreciate you walking us through these two cases. It sounds like there's a lot here for both agency contracting officers and the contractors themselves to consider.
Absolutely right. So agencies need to be thoughtful about this process, and it's built into the law, a mechanism for the agencies to get what they need when they need it, notwithstanding the protest function. But that really should be reserved and typically is reserved for very unusual circumstances. It's not where the situation is urgent and compelling because you let things wait too long, which has occasionally happened. It's not where there are obvious alternatives. It's where this is a real national security issue or this is a real emergency. And that's going to justify not waiting even the 100 days for GAO to issue a decision.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Listen to the Federal Drive on your schedule. Subscribe wherever you get your podcasts.